This case is horrible. And I mean, I know he says he's pleading to a one-time penetration. Court is calling 2023 CR 0543, State of Texas versus Wilbert Villamil. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Villamil.
And are you Mr. Villamil?
Yes.
Are you gonna have to speak up so I can hear?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Villamil, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 3 and waiving counts 1 and 2.
Any objections?
No, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of aggravated sexual assault of a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years in prison and life and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes,
Mr.
Your
Villamil, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, has your client had a chance to confer with an immigration attorney?
I have conferred with an immigration attorney. I have informed him that a plea to this is, he's actually a permanent resident. A plea to this would be a certain denial of future permanent residency and deportation after serving a prison sentence, which is what he's pleading to.
All right. Mr. Vial, did your counsel advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
What was that again? Sorry.
I said, did your attorney advise you of the consequences of entering a plea in this cause number, either no contest or
Yes.
guilty, and how that applies to federal immigration law?
Yes, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from the United States, or the denial of naturalization?
Yes, Your Honor.
Do you understand the consequences of entering a plea in this case as it relates to your immigration status?
Yes, Your Honor.
All right. Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Sir.
According to the plea, you're pleading on count 3. Punishment is to be assessed at 15 years in the prison. There are no applications. There's to be no contact with the complainants, and there's Chapter 62 compliance. Did you understand?
Yes, Your Honor.
All right. Here's my question, because I see that affirmative finding of family violence has been crossed through. Is this
Exactly.
complainant his relative or not?
Yes.
Okay.
Yes.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
I know we offer State's Exhibit number 1 and all attachments.
Okay.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. Court will find you guilty. Is there a reason I should accept this agreement? Why am I accepting this agreement?
Well, Your Honor, in this situation, what he has pled to is a single count of a single time of sexual assault of a child, which is aggravated sexual assault of a child. He has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
State, why should I accept
Your
this
Honor,
agreement?
Your Honor, the child is very young. She's in therapy right now. I discussed it with the mother. And this is, there is a desire to get closure early on in this case, Your Honor.
So
At this point, we haven't had to re-traumatize the child by bringing her in and talking to her about this case yet.
this case is horrible. And I mean, I know he says he's pleading to a one-time penetration, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal
Yeah.
issues with that. So,
but I mean, having a child having her brother lick his butt.
that was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to like beat around the bush. She was showing me her crotch, and that's.
And you got turned on.
No, I didn't. I'm telling you, I'm not like physically like. Well, I did get turned on, but not. Well, after a while, she just kept doing that. I tell her not. You know what I mean? Like,
So you blaming a 6-year-old?
I'm
Your
not
Honor-
blaming my
Your
6-year-old.
Honor, if I may, my client was sexually abused when he was a child.
How old is he now?
He's 35 years old now. But the trauma that he suffered as a child has definitely surfaced in a way that is abhorrent. It's in a way that is obviously is not good. And that's why we are here. And he is willing to go to prison, be a lifetime registered sex offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again legally. And he will.
So
have to
he's
live
being released to, after he does his time, released to go somewhere else and deal with his trauma that may result in him molesting some other child?
Well, he has, what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment. And of course, you know, he will at some point be wanting to go on parole. He knows that he's going to have to complete that. To do that, we have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that. And you know, at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life, which.
And what country would that be?
Mexico.
They have nice beaches there. So again, we go back to the point. What were you thinking?
Yeah, I can just say sorry, but like the only thing I can tell you is that I didn't like, I try not to hurt her. You know what I mean? Like,
Wait, are you saying that you were molesting her, and as you were molesting her in such a way because you didn't want her to hurt her?
no, I asked her. you can put this in your mouth. That's it. And she said, no. I said, that's fine. Okay, that's it.
No, this is not, this is a penetration.
Your Honor, if what he has pled to is, and what he confessed to is by penetrating the anus with his finger.
Mhm.
And he had told the police when they asked him that he told the police that he did that at the time, which is another thing. He was honest with the police. He told them what he did. You know, and at this point, we're asking for this because we have agreed early on not to leave this on a docket, not to go through the process, not to have his daughter have to come in. And as the prosecutor said, be traumatized by this, have to come in and talk to prosecutors, have to get the phone call from the DA's office. They want it done. They're going through a divorce. He's never going to have custody of these children. He's lost basically everything, including the country where he grew up. And he's going to lose his freedom for up to 15 years and for a minimum of 7.5. But as the court knows, parole doesn't happen like that for these cases. They're doing 85% of their time. And so he's lost his freedom for more than a decade. He has done a horrible thing, and there's nothing that he can say right now that can explain that. I think the court's questions of him, how he has confessed to you, and now that he has done it, and what
No, he pled no contest.
He pled no contest because I advised it because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
Yeah, so I mean, I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
Sorry, Your Honor, I didn't do it. I didn't do it to like hurt my daughter. I'm begging and telling you, please. I'm telling you, please. I'm not trying to force my hand in her vagina or in her ass. I basically grabbed her and I put my finger where it shouldn't be. That's it. Like I can't, I don't know how to explain
No, so the way you're explaining it to me, you're making it seem like it was an accident.
No, it wasn't
So was it an accident or not? Because you're telling me you just grabbed her and you're making it seem like your finger just accidentally penetrated the
The
anus.
thing is, I just don't know what she wants. Like, she's spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole vagina at me, like at least 4 or 5 times. Dropping her pants, to, like literally. Like, it's not like I'm telling you like my actions were right.
I know, I'm just trying to figure out where you are mentally and yes.
So if I grab my daughter's butt and I throw her on the bed and I didn't like forcefully sleep.
Your Honor, at the time, he told police officers that he had put his finger inside of her anus.
So it wasn't accidental. Am I right in assuming that?
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. We are asking the court to follow this plea bargain. It is obvious that the man has sexual deviancies, and it's obvious all of those things that we have for people who are charged and people who are convicted of this. All of those things we're doing here. He's going to the penitentiary. He's going to be a registered sex offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child, and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right, so this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had discussion with the mother, and the benefit of the child was to get this done, have no right to appeal, so the child could move on. It's up to the court's discretion. I'm happy to reconfer with defense counsel as well on this.
All right, if you all want to reconfer, the court would be willing to accept a plea of 20 years, not 15. If you all want to reconfer on that, you can.
Okay.
All right.
Your Honor, 2 things. I'm set in jury trial in County Court 13. They're starting to pick the jury now.
Oh, tell them you're in felony court. I'll call County Court 13.
It's Judge Skinner. It's County Court 13 impact.
I'll call them. So if you all want to confer and see if he's willing to accept 20 years,
I can't talk to my client about something like this in the matter of a few minutes. I mean, this is something that we just asked for a reset. If that's what the court is asking us to do, it puts too much pressure on the attorney-client relationship for me to talk to him in the box about a complete reworking of this plea bargain. I spent hours with him in the jail, going over discovery, doing all this stuff, and this is I'm asking for a new setting.
all right, Ms. Ferguson, recall this for tomorrow.
And if I'm in jury trial
Oh, tell 13, you need to be here tomorrow.
and have her jury wait.
Yes. This is district court. So I'll see you all tomorrow. Diaz Hernandez Rivas. Court is calling 2023 CR 3139, State of Texas versus Cynthia Nicole Cabello. Should I have parties announced for the record for the state?
Brittany Mitchell to the state.
Defense. All right, and are you Miss Cabello?
Yes.
Am I pronouncing your last name right?
Yes.
Thank you. The double L's always throw me off. Counsel, have you received all the discovery and did you review it with your client?
I have them.
Court will find that the state is in compliance with discovery. Ms. Cabello, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Well, Your Honor, there should also be, we filed a written motion to amend to add account 2, criminal mischief.
Any objection?
No, Your Honor.
All right, Ms. Cabello, do you understand that the state is asking that the indictment be amended to add a count 2, which is a criminal mischief count? Did you understand that?
Yes, Your Honor.
Did you understand that's a substantive change to the indictment?
Yes.
And did you understand your attorney has 10 days to prepare for trial with that substantive change? Knowing that, do you still wish to proceed?
Yes, sir.
And defense, do you still wish to proceed?
Yes, Your Honor.
All right, then the court will sign the motion to amend the indictment. Ms. Cabello, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're being charged with the offense of criminal mischief? $2,500 to $30,000. Did you understand?
Yes, Your Honor.
That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
She has them.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Cabello, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your
Has anyone promised you anything other than the plea?
No, Your
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived a right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2, criminal mischief. They're recommending deferred adjudication. There's to be restitution, if any, to Ernest Ramirez. No contact with Ernest Ramirez, his residence or place of employment. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years, 200 hours community service restitution, TAP evaluation, follow recommendations of TAP, and a MIC referral. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to count 2 of the amended indictment, how do you plead? Guilty, not guilty, or no contest?
No, sir.
State any evidence?
And we offer state's exhibit number 1 and all attachments.
No objections. No.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. State, has the complainant been contacted?
Yes, Your Honor.
All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt. Are we pleading, proceeding with sentencing?
If the court would allow us, yes, please.
All right, anything you wish to say on behalf of your client?
Your Honor, this is her first ever criminal offense. She was going through a very bad time. Mental health breakdown, and she's doing much better. She's compliant on her medications. She's doing very well, Judge. She's working again.
All right. Ms. Cabello, how long had you known Mr. Ramirez?
7 years.
Did you all ever live together?
No, Your Honor.
Do you all have any children together?
No, Your Honor. We had keys to each other's houses and stayed with each other, but never officially lived together. And that was for 5 years.
All right, and how old are you?
39,
And how old is he?
43.
Do you all have any property together?
No, Your Honor.
All right, and do you have a mental health diagnosis?
Yes, Your Honor.
Oh.
Multiple.
And what is it?
I have multiple. I've got anxiety, major depressive disorder, adjustment disorder, PTSD, personality disorder.
And are you seeing a doctor?
Yes, Your Honor. I have a weekly therapy sessions.
And who is your doctor?
It just changed. His name is Michael something. I'd have to check on my phone.
All right.
She's treating through the UT health system.
All right, this is what the court is going to do. Court is going to sentence you to 5 years deferred adjudication. Restitution, if any, to Ernest Ramirez. No contact with Ernest Ramirez or his residence or employment. So if you see him walking down the street, you need to cross the street, go back the other way. You understand? Zero contact. As far as this court is concerned, your relationship is over with him. If you have contact with him, you're looking at potentially going to prison, the state jail facility, for 2 years. Do you understand?
Yes, Your Honor.
Your Honor, if I may clarify one issue in regards to the place of employment. He is an officer with the UT Health Science Center Police Force. She used to be a dispatcher there. She is treating through the UT Health Science Center and has been for like over 10 years. Is that right?
Yes.
And her daughter is also treating at the same, through the same.
I mean, she'll allow to be there for treatment, but if it's not her day for treatment, she's not to be there.
I just wanted to clarify that so the court would know that she will be going there for treatment. She doesn't go to the police department or anything like that, but there's no way to tell where he will be on any given day at any given time.
All right. So are you employed or no?
I'm employed now. Yes, ma'am.
All right, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors.
I work in a pediatrician office,
Doing what?
the front desk.
Oh, see, when I say no employment as a home health care with minors, what I mean by that is, yes, it's okay for you to check them in, but you're not to watch them. You're not to act as a daycare. You're not to be one-on-one with them.
Yes.
So when their parents bring them in, you're just signing them in. You're not giving them shots or anything of that nature. You understand?
Yes.
All right. Are there any drug issues?
No, Your Honor, not at all. It's all prescribed medications.
All right. Probation, we'll still do a TAP evaluation. If they recommend inpatient treatment, we'll start with outpatient treatment
Thank you.
and sober support meetings. And we'll do a MIC referral. 200 hours of community service restitution. She is to continue with mental health treatment through her provider. And the exception to contact with the complainant is only if she has a medical appointment. Since they're both at the same location. But even if you have a medical appointment, I don't see how you would have contact with him.
It happened once where they were both on the same floor at one of the facilities and they crossed each other. They did not speak.
Okay. Probation, is there anything else she needs? We'll do field visits one time per month for 3 months. And probation, if everything is fine after that, you can do field visits as you see fit. And there'll be regular reporting, of course, by Zoom or in person. And regular UAs. And with the UAs, if you want to do that by a patch, you can. I think the patch is probably going to come up positive depending on what medication she's on.
She's on a number of them.
So just make sure that you give probation all of your prescription medications so they'll know.
Yes, sir.
Probation, is there anything else? Is there anything else that you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So I'm very serious about you having no contact with him outside of if you all accidentally bump into each other when you're have your medical appointments.
Yes, sir.
I understand. Sometimes people get caught up in love. Sometimes you're in a relationship and people are like, I don't want you. And then it's like, okay, let's try this again. I want you now. This relationship is over. You understand?
Yes, sir.
All right. And this court communication is key. So if there's an issue, let probation know. If you feel as though probation is not addressing it, you can always come back to the court. Okay.
Yes, sir.
All right. Good luck to you.
Thank you.
You're welcome.
Thank you. Maybe.
Yes. And probation will go over her conditions. All right, we're going to go on the record. Court is calling 2019 CR 10379, State of Texas versus Christopher Caballero. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Ruben Pisania for Mr. Caballero.
And are you Christopher Caballero? You need to unmute.
Okay, yes, ma'am. Christopher Caballero.
And I'm going to place you on mute. Your client is appearing by Zoom. Any objection from the state?
No objection, Your Honor.
And defense, I'm assuming you have no
No
objection.
objection, Your Honor.
And Mr. Caballero, if you could unmute again, please.
Okay.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Christopher Ryan Caballero?
All right. Do you have any objections to appearing by Zoom?
No.
All right. And you understand that you do have the opportunity to appear in person in court?
Correct.
All right. Thank you. All right. We are here for a motion to return of seized property. And the property that the defendant is asking be returned is a loaded Springfield Armory XD 9mm handgun with 1 magazine and 12 live rounds. A Saiga SAIGA 7.69mm rifle with 1 magazine and 10 live rounds. And those are the weapons that you're asking to be returned, counsel?
Yes, Your Honor.
And you're not asking for the magazine to be returned, are you?
Not the live ammo, but the magazine and the weapon.
So you're not asking for any of the live rounds?
No, Your Honor.
All right, we previously had a hearing on this, and I asked everyone to review any case law because I don't think your client should have these weapons back. But I know what the law is, and of course, I will always follow the law. I think it's odd that someone has a drug case and now he's concerned about some weapons. And I don't even think these weapons are antiques or some weapon that you can't find everywhere. Is it just the expense? Why does he want these weapons back?
Yes, Your Honor, just because he did purchase them legally under his name and they are his property. They're relatively valuable, probably around $2,500. So that's a substantial amount of money for him.
Your Honor, I believe, is there some case law you had?
Yes.
So I believe the defense has some case law that he cited in his motion. I was unable to find any case law that says that to cite to bring before the court today. It is our policy to oppose these types of requests to get weapons back, Judge. And there was a version of the defense motion that requested the weapons be returned to defense counsel rather than the defendant himself. So we would request, if you were going to order the weapons be returned, that they be returned to defense counsel rather than the defendant, Judge.
Do you want them returned to you?
Your Honor, if that's what the court wants, as long as the court allows for us to then return them to him.
No, I mean, it's just either yes or no. Do you want the weapons returned to you or do you want them returned to your client?
To my client, Your Honor.
All right, so the court has reviewed case law. And under Article 18.19 about seized weapons, if you all want to review it and look at it, it says, weapons seized in connection with an offense involving the use of a weapon or an offense under Penal Code, Chapter 46, shall be held by law enforcement agency making the seizure subject to the following provisions. Unless the weapon is a prohibited weapon identified in Penal Code, Chapter 46, and Chapter 46 has to do with all weapons offenses like unlawfully carrying, or the weapon is alleged to be stolen property. So the first question is, do you have any documentation that these weapons are his?
Your Honor, I did ask my client. He said that it may be possible for him to procure a statement like either bill of sale or receipt from when he purchased the weapons. But he did say he purchased them himself, so they should be under his name.
All right, so one, that's what the court is going to need to show that these are actually his weapons.
Sure.
All right. Now, the other thing, if there is no prosecution or conviction for an offense involving the seized weapon, the magistrate to whom the seizure was reported shall, before the 61st day after the date the magistrate determines that there will be no prosecution or conviction, notify in writing the person found in possession of the weapon that the person is entitled to the weapon upon written request to the magistrate. So he's already requested it back. D, a person either convicted or receiving deferred adjudication under Chapter 46 is entitled to the weapon seized upon request to the court in which the person was convicted or placed on deferred adjudication. However, the court entering the judgment shall order the weapon destroyed or sold if the person does not request the weapons before the 61st day, which he has. The person has been previously convicted under Chapter 46. So I need to know whether or not he's been previously convicted under Chapter 46. The offense for which the person is convicted or receives deferred adjudication was committed in or on the premises of a playground, school, video arcade facility, or youth center, as those terms are defined. So I don't know, because this is a pretrial diversion. I don't know where he had the weapons. Or the court determines based on the prior criminal history of the defendant or based on the circumstances surrounding the commission of the offense that possession of the seized weapon will pose a threat to the community or one or more individuals. Here's the issue. It has to be a conviction or receiving deferred adjudication. He wasn't convicted. He didn't receive deferred adjudication. So if he provides proof to the court that these are his weapons, either through a bill of sale or some other documentation that the court can view, I am obligated legally to return the weapons to him. Do I think the weapons should be returned to him? Absolutely not. Do I think it's odd that he received a pretrial diversion for a drug case and he's concerned about weapons? That should be the least of his concerns. But legally, I must return the weapons. So I will return the weapons once he provide proof to the court that these are actually his weapons and not someone else.
Your Honor.
So he needs to provide that. And once that's provided to the court, we can place it on the record that I received that and we'll go from there.
Yes, Your Honor.
And that's the case law or the statute that the court has seen. If, when he provides the bill of sale, if he can, if somebody finds some new case law or something new happens, you can always let the court know. We can go off the record. But as it seems here in Texas, they're even close to passing a law where people who violate protective orders, that they can have their weapons back. And I think we're going to get to the point where even if you have a domestic violence case, I think the government, the Texas legislature is looking at even giving them weapons back. So that's where we are.
Yes, ma'am.
So, and if you all would like, you can, the article is 1819.
Yes, ma'am.
And so counsel, as soon as you have that information, just come back to the court.
Absolutely.
Okay.
Thank you, Your Honor.
And I'll make sure that I look at it and review it. And if somebody has an issue where you think, oh, this is not the appropriate bill of sale, just let the court know.
Absolutely. And I'll provide it to you in advance.
All right.
Is my client excused?
Yes, your client is free to be excused. Thank you, Mr. Caballero.
Thank you very much. Have a good day.
All right, where are we on this case?
Judge, I just got appointed.
Yes, I know.
A few minutes ago.
Yes.
Judge, we haven't had a chance to confirm yet.
All right, so I'll let you all confer. And what I'll do is I'll give you all a 30-day reset, and that will be for discovery to make sure you have your discovery information. And then after that will become a plea deadline date. Then after that, potentially a jury trial date.
Sounds good, Judge.
All right, could I have a 30-day reset on Al Anezi? Is that how you pronounce your last name?
Alanis,
Oh,
Alanis,
Al-Nazis?
Alanis,
Al-Lazis?
Al-Anisi,
Al-Anezi?
Anisi.
Alazi.
Yeah.
Okay. All right, I'm gonna work on that, I promise. Judge, August 15th.
Judge, with all due respect, I was appointed to him. Did he hire a lawyer or?
No, yes. All right, so let me ask you this, does he need an immigration attorney?
We have one on staff, Judge.
Yeah, that's why we're
Yes.
moving it. It's got a high needs case.
All right, and does he have interpreter needs or no?
That's why.
And we'll work on that too, Judge.
All right, and is it Farsi or what is Arabic?
Yeah.
Okay, my Arabic is shaky, but one of my friends was Arabic. Well, they're still alive. They're Arabic. They taught me certain things. I don't know a lot of the language.
Well, if they're
Yalla.
available to come in and.
I don't know that one. That's all I know. Okay, see, I know hurry up in every language. All right, so interpreter Arabic. All right, so that's your new court date. Your new court date is going to be on August 15th, and that will be for discovery.
Thank you, Judge.
All right, thank you.
Thank you so much.
You're welcome. Leslie Cox.
Who's present, right, Judge?
Oh, wait a minute. This is Kimberly Burley's daughter. Hi. Judge Burley's daughter, I should say. All right, so where are we on this case? You have all the discovery?
I don't, Judge. There, it's the Live Oak PD case, I have that discovery. and I
Ah,
have all the
okay.
discovery. So some videos were sent to the DA's office. Those are going to be uploaded today.
Mhm.
I'll need some time, of course, to get those, review those, et cetera. It's our first setting. We do have an offer. We have represented the court that we have received that part of the discovery.
Okay. All right, Ms. Ferguson. On Leslie Cox, can you give them a 30-day reset for discovery?
Sounds good.
All right, and Ms. Cox, you were late today. Why?
There was a wreck on the highway right here.
Was this the wreck they have on 90? You
Yes.
know, people, I was behind that wreck. So that's why I always tell people you need to leave early to anticipate this thing. And everybody thinks they're going to get $1 million, so nobody wants to move it to the shoulder. So everybody, accidents, move them to the shoulder. People can tell you were hit behind by your bumper. So, all right, so we'll see you then. You're welcome. Just sign the reset form, then you're excused.